Well, thank you for being here. Good afternoon. I'm Don Murray. I am a co-chair of the Corporate Finance Department here at Dewey. We are proud to be a supporter of the Legal Insights, Critical Insights lecture series that Catholic University Law School puts on. And we are, as I said, delighted to have you with us here this afternoon. The new and inventive securities, the openings and closings of new issue markets tend to be the attention grabbers in the financial press and in the business press, but the health of the new issue market really is dependent on having a healthy secondary market. And what our program today is going to explore is what may well be the final frontier, if I may, in secondary trading, that is, in trading in the securities of of private companies. And to explore the topic, we have with us today on my immediate right, Professor David Lipton, who is the director of the Securities Law Program at Catholic University School of Law. Professor Lipton is a frequent speaker and is often quoted on topics relating to securities regulation, broker-dealer regulation, securities arbitration, insider trading, the impact of technology on securities regulation, and just about anything else that anyone will ask him if they put a mic in front of him. He served on the DC Bar section on corporations, finance, and securities, including serving as the chair and vice chair. He literally wrote the book when it comes to broker-dealer regulation. His treatise on the topic is recognized as the last word in the industry. David has written other books and articles too numerous to mention. He's done stints in the private sector. He's worked at the SEC. He's worked at what was then the NESD and is now FINRA. He's lectured or taught at places as disparate as DC, Beijing, Bologna, and Krakow. And the last credit I'd like to give him is that as my securities professor and mentor, he launched me on my securities career 27 years ago. So I am delighted to entrust you all into the very capable hands of Professor Lipton. And David, take it away. I'll have a seat.
Thanks, Don, and thanks to Dewey LaBeouf for sponsoring us, and good work of Eric and Don. I usually ask that if former students cite me as their professor, they indicate that I was a child wonder, and I started teaching shortly after my bar mitzvah. And Don was rather elderly when he went to law school, so that's we're roughly the same age now. And it's interesting. I looked at Don's outline, and I was impressed. It was typed up, and I tried to explain that's not quite what we do in academia. I don't know if you could see this, but a little bit about the program. The law school at CUA has had for a couple of decades now, I guess a little bit longer, a securities law certificate program. Graduates of the program go on to the SEC, CFTC, FINRA, most of the large financial firms in DC, and a fair number in New York, Boston, and Chicago. We're proud of our alum. We try and get around and talk to them every once in a while. I used to come up to New York more frequently, but they understood that I had ulterior motives because Eric and I would sit around drinking all night along with Keith and a couple of other folks in the audience. So they cut that back, and they waited till they got this critical insight program, and they said, we'll try and see if Lipton could do critical insights. And right around that time, I was looking at what was going on with Goldman and Facebook. I think that it was an unusual phenomenon. The second market came up in the news a lot, and I thought we ought to pull together a panel on precisely what Don mentioned. Since that time, I've been encouraged to see, I think, the movement, the direction that Don spoke of a liquid second market, allowing for ultimately public offering distribution by private companies that amount to a public offering are substitute for a public offering. I have to be careful with my language. And that acceleration of that process is perhaps going to occur thanks to legislation that's percolating through Congress and thoughts at the SEC of raising the threshold trigger for Section 12G registration, the development of a number of research firms that are now doing work more with the private equity groups and with the public equity groups, and the continued population of second market trading platforms. Interesting, someone sent me the deal book, New York Times deal book article yesterday on Kerner. It's Ken Kerner, Ron Kerner, Lou Kerner, joining with Liquidity on their private equity market. And his quote was, "We're at the beginning of the emergence of this new asset class," Mr. Kerner told Deal Book on Monday. "With the emergence of the secondary market, you could attract all the capital you want without going public." Well, I'm not sure that's so, but that's one of the things we're going to discuss. I asked a number of experts in the field to come and join us. To my immediate right, General Counsel of perhaps the most prominent of the secondary market outfits, Second Market. Off to Anne Marie Tierney's right is Andrew Brady, and he's going to be discussing some of the legal aspects of distribution of restricted securities. Andrew Brady is counsel with Skadden. Off to Andrew's right is someone who I'm sure a lot of the audience are familiar with, partner here at Dewey, Eric Blanchard, who is interested in discussing this topic with you in terms of its application for client wisdom. And finally, for the counter side, we put him well at the end, is Theodore Lazo, General Counsel Regulatory at NYSE Euronext. And he's going to talk a little bit about what the value is of those traditional markets. Going to try and keep it down to a 15-minute discussion of each of the panelists. I have a sort of an electronic device here which will stimulate their departure from the podium. We will save questions at the end for you. We might have a few panel questions after everyone speaks. We'd like to end up completing matters in about an hour and 20, an hour and 30 minutes. We're getting going a little bit late, so if we even manage to cut that short, that'll be fine. I'm going to turn the discussion over to Anne Marie, who's going to discuss the nature of probably the most prominent of these secondary trading platforms, Second Market. Thank you all for being here, and thanks to the panel for being here.
And I'm not going to stand at the podium because I don't want to get either electrocuted or tased.
That's
so I'll just stay here. My dear friend John D'Agostino gave me a glass of wine, so I think I'll be even more interesting after 2 sips of that than I would have been before. But thank you very much for coming tonight. I was also under David's extremely amazing tutelage as a securities lawyer. He's why I'm a securities lawyer. So if I make a mess of myself tonight, it's his fault. And I don't think, I'm not going to talk about how old I am, so you can not worry about that at all. But one of the things when we started talking about this panel, I've said this several times over the last couple of months to many people, but I think that we're at a point in the securities industry that's really, really, really amazing and unusual. And what's going on right now from a legal and regulatory point of view in the context of second markets, I find really remarkably interesting myself. So hopefully you'll find it interesting as well. For those of you who are not familiar with my company, Second Market was actually founded in 2005 to trade public company restricted stock. We've been a broker-dealer since 2005. In 2008, we started trading auction rate securities. About 3 weeks after that, market froze up, and that, to this day, fixed income is still the largest asset class that we trade. We got into private company stock more recently, kind of by accident. We were approached by a former Facebook employee in about 2008, and they said, I'm reading about the fact that you're trading restricted public stock. Could you help make a market in private company stock? And we found a buyer. We put the transaction together, and off it went. So it was sort of like that old Prel commercial. They told two friends, and they told two friends, and the next thing you know, we were being inundated with sell-side interest in Facebook stock, and we took a long, deep breath and started looking at the market very closely, and realized that there was a real opportunity for us here. And so where we are today, from where we were in 2008, where we started doing these one-off transactions, is a really interesting spot to be. Just some background on why I think companies like ours are getting so much traction in secondary trading. Nobody's going to be surprised by the fact that the securities markets have shifted, I think, probably forever in the context of when companies are ready to go public and when companies are interested in staying private. And there's a lot of reasons for that. Probably the three most significant in my mind are the fact that high-frequency trading now accounts for more than 50% of all U.S. equity trading. So if you're a public company but you're not particularly liquid, there's not a lot of interest in trading your stock. Also, because of a number of factors, there's very little research being written on small or mid-cap companies. So really below about $1 billion market cap, it's very hard for public companies to find an analyst who's willing to write about their company. And that's, I think, as a result of the fact that we moved from fractional penny increment trading to decimalized trading, so spreads on broker commissions are much more narrow, so there's a lot less money to pay for research below a place that's going to be making money for investment banks. And secondly, because of the Elliott-Spitzer actions and the fact that investment banks had to basically hive off research into a separate unit, many banks stopped doing research altogether, and many of these independent research entities that have come to be in the last few years are really focused only on very large companies. So what we've been seeing in the public company markets is companies that are public and yet very, very thinly traded or liquidly traded. And then obviously regulatory and legal changes that have happened in the last 10 to 12 years, including Sarbanes-Oxley and Dodd-Frank, and all of these other rules and regulations that make it very costly and probably more risky for companies to be public companies. So what we've been seeing is a shift in the way that companies think about going public. I think the last statistics that we've seen is state something like it used to take most startup companies 4 to 5 years to go public. Now it's taking more like 9 to 10 years. But in the context of that time lag, they're still giving out equity to their employees. And so you have a growing number of former employees and a growing number of existing employees who want to get liquidity for that equity before the company's actually ready to go public. So there's quite a pressure on companies to create a way for these people and these employees to find value for their stock before they're actually ready to go public. And so that's sort of where we've been able to step in. What we saw in the last 2 years, really in 2010 and 2009, were practices that were very problematic. We saw things like single-purpose SPVs with single stock investing start to proliferate, where they would sign contracts with sellers to purchase stock before they actually had the money to buy the stock. And so we saw a lot of broken trades where the funding didn't come through and sellers were very frustrated. We saw a lot of situations where sellers or buyers might have been insiders and had obviously much more access to information than their counterparty, and that led to a lot of real concerns over what did people know at the time that they made the decision to buy the stock and potential rescission rights issues. We also saw problems with getting legal opinions. Most private companies, for those of you who don't know, have a right of first refusal to repurchase the stock. So you would see a buyer and a seller find each other, but not realize that there was a right of first refusal until they actually put the documentation into the company's transfer agent. And in that case, the buyer wasn't able to get the stock, and the buyers were unhappy. And so I think, based on a lot of factors, we were doing these one-off transactions where we would find a seller, find a buyer, put together the package of documents, and kind of ship it out to the transfer agent. We would get paid regardless of whether our buyer bought the stock or whether the company invoked its right of first refusal. But we were also getting a lot of pressure from companies who were unhappy with how secondary trading could impact their 409A valuations and therefore how much they, gave their equity to their employees at what price. They were concerned about insider trading. They were concerned about their 500 shareholder threshold and their inability to control that without exercising the right of first refusal. So as we got into 2011, my company made a complete kind of sea change and shift. So now the way that we transact in the private company market is only in the context where a company actually signs a service agreement with us, asking us to create what we call a liquidity program for their secondary shares. And in that context, the companies have complete discretion around all the parameters of the transaction. They decide when the trading window opens. Is it once a year? Is it every 6 months? They decide who can sell. So is it existing employees? Is it former employees? They can decide to put caps, for example, 30% of existing vested holdings. They can decide who the buyers are. They can decide to only allow current investors to buy. They can allow only institutional investors to buy. On our market, we're following the IPO net line of no action letters, so all of our buyers are accredited investors or better. But some companies don't want more individuals, accredited investors. They only want institutions. So we provide the company a way to manage the 500 shareholder threshold in a way that's legally and regulatorily compliant. And we've really seen companies respond very well to this. And so the thing that I think we've met a couple of times with corporation finance at the SEC to find out sort of what they think about our marketplace and ways that we can do things better. And the two things that they were most concerned about is how do we know for sure somebody's an accredited investor, and how do we make sure there's no insider trading, and what do we do about information disparity? So the first thing we did about accredited investors is our minimum transaction size. First of all, our average transaction size is about $1 million a trade, but our minimum investment size is $100,000. And so in the context where we don't know a buyer, we actually require them to escrow the proceeds up front or show proof of funds. And we do background checks because we're a broker-dealer. We're doing AML. We're doing Know Your Customer. So we're very comfortable that we know who the buyers are as we put them into programs. So it's made a big difference. And sellers are very confident that there's not going to be broken transactions. Companies are waiving their rights of first refusal in the context of opening up a liquidity program with us. And so there's real comfort on the sell side and the buy side that the transactions are going to occur. We run many of these programs as modified Dutch auctions, so sellers put their interest through, buyers put their interest through. We run an auction and set a price. But one of the most important factors I think about the way that our market operates is that because we're doing a program with the company's involvement, we actually require that companies provide disclosure documents to us. So they're providing 2 years of audited financial statements and interim financial statements. They're providing risk factors. They're providing their constituent documents. They're providing, depending on who the seller is or the buyers, if we have sellers and buyers who are all non-affiliates of the company, then we have a level of information that's basically financial information and risk factors. If there's insiders involved in the transaction on either side, we're actually providing information we're requiring that companies provide information that's almost at an offering memorandum level. So this has just been a way that we've been able to help people get comfortable about trading in secondary shares. We actually just did a transaction ourselves in our own shares. Andrew helped live through this with us, but our existing shareholders sold about $13 million worth of shares to buyers that we approved. We got some great new investors in our company and learned a lot about how to make the process better. Our platform's electronic, but I often describe it, and Tara will appreciate this, as kind of the old NYSE specialist model where interest comes in electronically from buyers and sellers to the platform, but it's very human intensive in the context of what gets done in order to do price discovery. And we're not a stock exchange. We don't do continuous trading. We don't have real-time trading. And I think that what was surprising to me when I joined the company, because I've been a public company lawyer for 20 years, is the amount of time it takes to close a private transaction. So whereas we're very used to T+3 in the private company planet, even in the context where a company waives its right of first refusal, the transaction settlement time is something like 10 to 15 business days. So this is not quick. This is not real time. And We're just trying to find ways to make it as efficient as possible and help companies achieve the goals that they have to create liquidity for their shareholders and make the decision for themselves about when they're ready to go public. Because we think going public is a very important step in a company's development. We just don't think the company should have to go public when it's not ready to do so just because it has 500 shareholders.
Great job, Anne Marie.
Okay. Thanks. Do I get an A?
You're coming in at 12 minutes. Why don't we take one or two questions from the panel, and I'll be a little bit piggy and ask lead off one. I was going to ask you what the pricing mechanism is. You referred to a modified Dutch auction. I don't know if that's your exclusive mechanism. It's not.
I mean, if the block's big enough and we have it makes more sense, we'll do just a more standard negotiated price transaction. I think I should have also made the point that we only earn revenue from completed transactions, so we make a 2 to 5% commission on completed transactions, and that's the only way we get paid. You don't have to pay to join Second Market as a participant or as a company who wants to do a liquidity program through us. We basically take a commission off the seller's proceeds. But the company decides how the pricing is going to occur, and companies can decide to set a reserve price that's their 409A valuation or something below that. Or they can set a maximum, say the maximum that the transaction go off at is our 409A valuation, so they can help control that price. We've also served as an information agent in the context of third-party tender offers. And in that case, we're not doing price discovery at all, but we're acting as an information agent, paying agent, escrow agent, and facilitating the whole transaction for the company and the participants.
That also answers my second question, which
good.
was,
Are we done?
I thought maybe I'd open up the rest of the panel, but a good number of news articles have looked at the pricing on Second Market as a means to value Facebook. I forget what other companies they refer to, and I was wondering how accurate a valuation model that is, and what you're sort of saying that in some ways it is the limits. Both the high and the low might be set by the company itself.
It's possible. Yeah, exactly. And, one thing, I know that there's a lot of reports on, what prices are in Second Market, but we don't actually provide historical transactional information. So you can't sign up onto Second Market and say, okay, what's been the price of, just pick a company, Twitter or, whatever, over the past 6 months. We don't provide that information. So we really generally provide participants who've been approved to participate in a specific liquidity program. We'll provide them with maybe 4 to 6 weeks of pricing if we've been doing weekly auctions, which we do in Facebook. But for companies that are running liquidity programs, which are these once or twice a year programs, which are quite different, then there may be no historical information on pricing to provide them. So then they're really looking to things like we have never transacted in a company stock where the company hasn't done at least 1 or 2 rounds of preferred financing. So you're looking at the preferred price. You're looking at what the preferreds paid for the stock, the preferred stock, or you're looking at the company's 409A valuation. But all of that type of information is available to the market participants.
That's great. Anyone else from the panel? Why don't we move along, and Andrew Brady, as I mentioned, is going to be speaking a little bit about the specifics of the legislation and the rules that apply to the resale of restricted securities.
Thanks, David. So Anne-Marie was referencing liquidity programs, and what I thought I would do with my remarks is to briefly address some of the more prominent 33 Act and 34 Act issues that arise in connection with these resale transactions in private company stock. And then to the extent that I have a little bit more time, and David hasn't zapped me, we will talk about recent legislation that directly impacts secondary markets for private stock, or that might otherwise be of interest to private companies. So I think folks need to realize that, at least at their core, the issues and analysis that are involved in an online trading program like second market are not really new, and in fact, there are fundamental securities law issues that have been around for a long time. And given that, I thought I'd give you, a quick refresher that I first learned from David back in the day. 33 Act. All offers and sales must be registered or exempt, or such transactions will be illegal. The transactions that are contemplated on a trading platform like Second Market are structured to be exempt from registration. The 34 Act piece that you heard Anne-Marie talk about, and that some of the other panelists will talk about, is Section 12G. And Section 12G and the rules thereunder provide that if a company has greater than $10 million in assets and more than 500 record holders of a class of equity securities at the end of its fiscal year, that company is going to have to register that class of equity under the 34 Act. And so private companies need to keep their eye on the ball unless they want to trip up and end up owing a Form 10 to the SEC. So let's first talk about buy-side compliance and how potential buyers are vetted. And as Anne-Marie said, buyers are vetted in accordance with the 96 IPO Net No Action Letter, which permitted a registered broker-dealer to pre-qualify prospective accredited investors by way of a generic questionnaire. And the questionnaire is used as a means to establish the pre-existing substantive relationship with the broker-dealer that is necessary for the broker-dealer to provide the accredited investor access to the private offerings that are going on the password-protected area of the online trading program. And you need to have this pre-existing relationship, this substantive relationship in place to avoid tripping up on the ban on general solicitation. So the guidance in the IPO Net No Action Letter had a number of conditions. I'll walk through them very quickly. First, the questionnaire does not reference, it cannot reference any specific transactions that are posted or will be posted on the password-protected web page. Second, the password-protected web page is only available to a potential investor after they've been qualified, and that investor, third, can only access transactions that are posted after their qualification. So those are a couple things that folks need to keep their eye on when they're onboarding potential buyers to the trading platform. One thing that the letter did not address is what type of information is necessary for a broker-dealer to form a reasonable basis that an investor is sophisticated or accredited. And I think that that's an interesting point. The SEC has publicly stated that it's in effect troubled by self-accreditation, and that self-accreditation can give rise to a deficient pre-existing relationship. And if you have that, then you've got a general solicitation problem, and chances are you're going to have a hard time laying claim to a valid private placement. And these issues do pop up. I think some of us may have read about a couple months ago a competitor of Second Market that is out there, and there was a journalist from the Wall Street Journal who got their dead grandmother accredited as an investor in this competitor. So, something like that, I look at that and I say, there is a self-accreditation problem, and you're going to have a problem with the private placement there. So let's move on to the more fun stuff, which is the sell-side compliance. And I'm going to talk about the exemptions under 4.1 or 144 or 4.1.5 that may be available to folks on the sell side. And I'm going to look at this through the prism of something that is hopefully understandable to folks here. The resale of option shares underlying an employee stock option, where the exercise may be funded through the resale of a portion of the underlying option shares. So let's start with 4.1. 4.1 is intended to differentiate between public distributions, which require the protections of the 33 Act, and ordinary trading transactions, which do not. The exemption exempts transaction by persons other than the issuer, dealer, or underwriter. And it's the underwriter piece that typically is at issue when someone's laying claim to the 4.1 exemption. Whether someone is a statutory underwriter in connection with the resale transaction is always going to be a facts and circumstances analysis, and you're going to have to evaluate whether that seller is acting as a conduit for the issuer in a distribution or otherwise took the securities with a view to distribution. And I think folks need to keep in mind that the SEC takes the view that a public resale of restricted securities in reliance on the 4.1 exemption it raises serious questions about whether the seller is merely a link in a chain of transactions whereby the securities end up in the public realm. And so, in the example that I posited, where restricted securities are sold by an issuer in an exempt transaction, and they have not been held for a sufficient period of time, where they have not come to rest, as the option shares are in the example that I posited, then any public resale of those securities is likely to be viewed as part of the issuer's distribution, and the seller is going to be viewed as a statutory underwriter selling on behalf of the issuer, and you're going to have a problem. So that, I think, is 4.1 in a nutshell. 144 is another means by which people may be able to sell securities. As you may recall, it's an objective safe harbor for determining whether a person is not engaged in a distribution and not an underwriter. The problem with 4.1 is that for a non-affiliate reselling private company securities, there's a holding period of 12 months. After the 12-month period, the shares are otherwise freely tradable. For an affiliate, the additional conditions of 144 would still apply. If you look at that 12-month holding period, it's going to present a problem for the seller in my example, because they're going to have the option, and at the time that they exercise that option, the holding period on the underlying shares begins at the time of exercise, not at the time of the option grant. And so that person will have held the securities for only a very short period of time. They will have not satisfied the holding period requirements under 144. So 144 is not available. And 4.1, in my opinion, is not going to be available given the very short holding period of the underlying option shares. So what is someone to do? How are they going to affect this resale transaction? That leads us to 4.1.5. And 4.1.5 is a hybrid exemption. It's not specifically located in the federal securities laws, but it's long recognized by the SEC and by the courts. And, it's a combination of 4.1 and 4.2. However, I think most folks properly recognize it as, a subset of 4.1. And the theory behind 4.1.5 is that a private transaction that would be exempt under 4.2, if undertaken by the issuer, would not involve a distribution if undertaken by an affiliate of the issuer or a holder of restricted securities of the issuer. And because there's an absence of a distribution, that renders the 4.1 safe harbor available. You don't have an issuer selling, you don't have a dealer, and you don't have an underwriter. So, there are a number of very prominent commentators out there and large law firms that take the view that 4.1.5 is particularly useful for affiliates or non-affiliates seeking to privately resell restricted securities that have not come to rest, the securities described in our example. And these commentators, and other folks take the view that the holder of restricted securities would not be deemed a statutory underwriter if the holder engages in a private transaction solely with persons who would have qualified for participation in the private transaction had they been approached by the issuer. So you have accredited investors, sophisticated investors, and if the seller establishes the issuer's right to the private placement exemption as to the other parts of the transaction. So let me try and put that in plain English, because that was probably a bit of a mouthful. The holder of restricted securities can rely on the exemption provided by 4.1 if the original sale by the issuer, together with all if the original sales by the issuer, together with all subsequent resales of the securities acquired in that offering, reflect the principles in 4.2. So if the issuer had a valid 4.2 and the seller has a valid private placement, you look at those together and there is no public distribution. And given the absence of the public distribution, you don't have an underwriter and you have a valid 4.1. Because the availability of the 4.1.5 turns not only on the initial sale by the issuer but also the downstream sales, many commentators take the view that you need to take certain steps to ensure that the transaction remains private. And these steps include ensuring that your buyer is sophisticated and accredited. He takes with a view towards investment. He's not going to be able to. He's not looking to resell. You probably want to get a rep to that effect. You're going to want to put a restrictive legend on these securities, and the issuer is probably going to want a stop transfer order out there to prevent downstream resales unless there is an opinion of counsel saying that those sales are exempt as well. So that is the 4.1.5 piece. And I think an interesting point on that is, Anne-Marie's talked about how they've changed their business model to make information available to investors, and I think that that's important. If there are trading platforms that are out there that are not making that information available, I think they need to keep in mind that, the SEC has never said what type of information, if any, needs to be available to lay claim to a valid 4.1.5 transaction. On the 34 Act side, I'll just talk real quickly. There's 12G. Everybody knows 12G, the 500 record holder problem. Folks that participate in liquidity programs need to keep an eye on that, and the things that Second Market has done around that issue, I think, are very smart, and you'll probably see a lot of people trying to do the same things. And if David will let me, I'll talk very briefly about some of the legislation.
Do the legislation, please.
So there's really, I'll call it the congressional interest and then the congressional legislation. There's been a series of exchanges between Darrell Issa and Chairman Mary Shapiro on perceived impediments to capital formation, and they've sort of gone back and forth this past spring. And the SEC has pledged to take a fresh look at properly balancing investor protection and facilitating the formation of capital. So the SEC is out there looking at all their rules afresh, or so they say. One of the things that we know that they're doing is there is a concept release on general solicitation, perhaps relaxing the current ban on general solicitation in connection with private offerings. That release is still a work in progress, but we understand that it is significantly along at this point. So perhaps that will be coming out at some point. As far as congressional action, there are a number of bills that are out there. Not surprisingly, most of them are coming from the House. And some of them increase the 12G threshold from anywhere to 1,000 or maybe 2,000. There are bills to remove the ban on general solicitations, a general solicitation that is currently in Rule 506. There are bills out there to exempt smaller companies from the requirement to provide an auditor's report on internal controls over financial reporting, and that would exempt all issuers below $500 million, and for issuers between $500 million and $1 billion, those folks, those if newly public, would get a 5-year pass. There are bills to expand the limits of Regulation A to 50 million. So there is, as Anne-Marie said, there's a lot of action right now with respect to federal securities laws, and a lot of things are happening. And I think it is an interesting time to be a participant in this arena. And that's about all we have for me.
Andrew, I had a question for you, but it links your talk with Eric's. Eric's is, by and large, what advice to give to clients. I heard you as saying that one of the exemptions that a seller could consider relying upon in going to a liquid secondary market is a 401.5, and in order, in my mind, to satisfy 401.5, you'd have to satisfy the common law requisites for a 4.2, the federal court common law requisites. And yeah, part of that was going back to Ralston, sophisticated investor, but it also, through the circuits, required information available that is roughly comparable to a registration statement, obviously not registration statement, and avoiding solicitation. And I'm wondering, and I could ask this of Eric, and I could ask it of you, and maybe you could both answer, does a second market, or a second market, a second market-like trading platform satisfy the common law requirements to obtain a 4.2, and thus give you the 4.1.5?
Well, I think if you look at what second market is doing, I would posit that it does, that you don't have a general solicitation. The buyers are brought in connection with the SEC guidance in the IPO net no action letter. Now, granted, that related to primary offerings, but I don't see why it should be treated any different for a secondary offering. So you have a pre-existing relationship between the broker-dealer and the investor. They make a determination on the accredited status, and so that provides your bases for being able to have valid private placement. The sales, the 4.1.5 sales, if they're done in connection with a sophisticated purchaser in a manner that otherwise meets the requirements of 4.2.
What about access to information?
Well, thankfully, second market is doing it the right way. If there was if you had a 4.1.5 transaction where there was no access to information, you would say, well, this person is accredited. They have the ability to fend for themselves. They're a sophisticated buyer. What would the SEC think of that? What would a court think of that? I don't really know. There are some court cases. They're a little bit mixed. It's a bit of an open issue.
Well, fortuitously, Eric is going to say exactly what he would be advising his clients as to.
And then do I get to weigh in as a client who solicited this advice?
Sure. Would
Okay.
you?
I'll let Eric go first.
Okay.
We spent a lot of time on this.
Well, I feel like I'm walking into a trap, but it does lead into some of what I'll be talking about here. So we've heard how second markets work. We've heard what the regulatory overlay is. It's complicated, but there is a system for doing it, and it's been done. It's basically the same laws that we've been using for 80 or so years. So I'm going to pick up from there and talk a little bit about where it fits in, talk about how private markets are right now, and then talk a little bit about the opportunity, because the theme of this panel is, are we standing on the precipice of a new era of private company securities trading? So first I'm going to give a brief lay of the land on, where we are right now. The largest and most liquid markets are, as we all know, the 144A markets. 144A markets are trading of restricted securities by qualified institutional buyers all as specified and laid out in Rule 144A. Now, these markets are very liquid. The volumes can approach or even be the same as what could be achieved in a public market. I think the largest private market out there is probably the 144A market for fixed income securities. And a large segment of that is high yield bonds. So when you hear about high yield bond trading, often it's 144A markets. I want to go into a little bit of the attributes of the 144A markets because it does sort of tie into the theme of disclosure. So when you do an offering under 144A, the primary information that you give, from during an issuance from the company to first issuance to investors, you put together a document that looks a lot like this. So you can see it's a fairly lengthy document. This is for a private deal. So this is a 144A fixed income marketing document. In addition, there's periodic reporting that's mandated by these large investors in the indenture. You often have balance sheets, income statements, cash flows on an annual basis, earnings releases on a quarterly basis, MD&A, whatever's negotiated. It often approximates what you would get in the public markets. There is actually now price transparency in the fixed income 144A markets with the advent of TRACE. Still bond trading is fairly complicated. It's all about finding pools of liquidity, so the pricing transparency may not be as much of a factor, but it is there and growing. And there's no risk of breaching 12G because 12G doesn't apply to debt securities. And 144A high yield bonds are traded book entry, which is awfully convenient. So it's a very liquid market. It's been set up over the last 20 years or so, and it approximates a public market, but it is private. Another large 144A market is for the equity of foreign private issuers. And these are foreign issuers who may list abroad on a foreign stock exchange and then do an international offering memorandum and sell into the U.S. A piece of that. And if it's into the U.S., it's going to be under 144A. So you're talking about equity of private companies, since they're not listed in the U.S., not U.S. reporting. There's a survey that came out somewhat recently that said that almost 90% of the initial sales by foreign private issuers into the U.S. were through 144A offerings, and that's 90%. That's up from 64% from 96 to 2006. So you can see that foreign private issuers are generally listing. It's a trend you read about in the Wall Street Journal. More listings abroad. They'll still sell into the U.S. in 144A, and just like the high yield market, you have. This is an offering memo for a This is the international offering memorandum. Truth be told, it's basically a wrap on an exchange filing on the Warsaw Exchange for a large European IPO that we worked on. But this is the 144A document. This is the disclosure that folks.
Is it all in Polish?
It's in English, translated. But there is a Polish document if you'd like to have a copy. So this is your primary information, and then there is periodic reporting. Obviously, they're traded on foreign markets. Foreign markets have their own continuous disclosure regimes. It's all got to be in English, which is great for us, and it's all generally mandated to be posted on the issuer's website. Again, great for us. It's traded on exchange, so there's price transparency. They're exempt from 12G under 12G 32B. So as long as they have the public disclosure on their website and some other requirements, the SEC says you don't need to register in the U.S. You don't have to worry about the 500-holder rule. And those securities are also book entry traded. You close through DTC. They're traded on DTC. So it's very easy. It's basically like being public, but for foreign private issuers, non-reporting, non-listed in the U.S. So you can see the similarities here with the high-yield market, fixed income market, and foreign private issuers selling their equity under 144A. It's very similar to what you have in the U.S. for exchange-traded securities for public offerings in terms of availability of information, price transparency, and book entry execution. And also, as an aside, there's also the threat of 10b-5 liability. So these are the same deal protections that they would require in an IPO, including 2 10b-5 disclosure opinions, one from Issuers Counsel, one from their own counsel. So these things have been thoroughly vetted. We've given opinions on them. It's as good protection as you can get. It's the same protection that you get for a IPO. So now compare this to your typical Reg D private placement. So in a Reg D deal, you have an offering circular, but it's certainly nothing like this. Private placement investors do often have access to a data room. They'll have some more private company type of disclosure, but it's not been vetted. It's not been processed like a 144A deal or a public offering. And after the deal, there's very little by way of public disclosure. So it really doesn't match up with those other markets. And it's almost axiomatic that, even as Anne-Marie mentioned, there really isn't historical price transparency. You can't go back and say, track it over time and, like you would for these other markets. And you have a high risk of triggering 12G, and becoming an inadvertent U.S. reporting company. And to make it even worse, as Anne-Marie mentioned, the settlement cycle is long because these securities are certificated. They have a legend. The transfer agent will require an opinion from counsel that says that this transaction has been completed in accordance with a valid exemption from registration, and that is expensive and friction. So that's all the bad stuff, right? So you consider that Reg Ds are available for anyone who's making $200,000 or more, but and everyone who's making $200,000 or more, you can buy into these into the Reg D private placements if you want to buy in a liquid security with skimpy information, and the value that you're paying may or may not relate to the value that could be found on a liquid market. Whereas if you're a QUIB and you have $100 million under management, you have access. So investors, large and small, benefit from public markets, transparency, liquidity. Large investors have the same thing in the 144A markets, but after that, you sort of fall off a cliff. And I think that is the opportunity for second market. I think that's if the QUIB markets can approach the public markets in terms of liquidity, then why not the accredited investor markets? It's fairly the same thing. There's it's more complicated from a regulatory point of view, but why not have accredited investor markets be similar to the QUIB markets? And second market is doing the hardest part. They're aggregating all the investors. They're pre-clearing the investors. So I guess my first piece of advice, what's the answer? How can they get there? I think that the answer is not something that people want to hear, but it is disclosure. I think that if private company issuers who approach a second market liquidity event similar to a public offering provide this kind of disclosure on a regular basis such that people expect it or used to it, it can foster that sort of liquid market. And I think that the closer you get to public company disclosure and 144A disclosure, I think that is sort of the door that needs to get kicked down. And that would attract the volume of investors that would support a liquid secondary market, and it would give them the basis for a reasonable basis for making investment decisions. And then you have to think about ongoing disclosure, and this is even more difficult. Periodic disclosure. Do you put out, balance sheet, income statement information, MD&A on an annual basis? Would you put out earnings releases? If you wanted to have a liquidity event and then have periodic liquidity events, would you have continuous disclosure at that point? I mean, at what point do you creep into basically a continuous disclosure? And then you may ask yourself, why bother? I mean, what's the benefit of doing a private company, liquidity program if you're going to be doing basically the same type of disclosure that you would be doing as a public company? Well, I listed a few. There's internal control audits, executive compensation disclosure, stock exchange corporate governance requirements, beneficial ownership reporting, Section 16, public scrutiny of required disclosures, SEC reviews, the plan of SPAR. I could go on. So, that I think is the promise of taking these private market that's fairly undeveloped and pushing it in towards something that's roughly equivalent to the quib markets. And a question that raises in my mind is whether the existence of second market will change the way that private equity buyers will structure their purchases. So typically you'd have a pre-IPO company with various classes of securities, and you would structure them so that you would basically be very limited in your rights and say you'd have tag-along rights, drag-along rights, rights of first refusal, and whatnot, so that the investors basically keep control of who else is going to be part of the investor pool. And these rights fall away on a liquidity event, such as an IPO. Would a second market, could you structure a deal where your liquidity event would be a second markets offering, or a second market offering, or something similar? It'd be interesting to see if you would take this into account. I mean, as we mentioned, the cycle for doing a registered public offering is now enormous. So would you bake into your corporate documents triggers for doing a liquidity event of no less than 30 million on write your definition, but some company that would essentially be second market, and have that be your liquidity event, have all your corporate all the fallaways, everything collapse together and basically be like a public company and be traded essentially on an accredited investor market that's a lot like a quib market. And I think that has a lot of it's sort of interesting to see if anyone will take that up. I think that's probably a few years down the line, but certainly it's an earlier liquidity event and seems to be somewhat more certain than the vagaries of the IPO market. Now, I guess this is where I get into some of the more tangible advice. So you still have 10b-5 liability. You don't have Section 11 or Section 12 for these transactions, but 10b-5 still applies. So if you're doing a second market deal, you probably should think in terms of an insider trading policy. I think issuers have seen that in the insider trading policy. The purpose of that is to insulate, frankly, the control persons, because under FREA, I think there's control person insider trading liability, so that if you're running a company and you don't have proper controls over folks trading your securities, then you could be held liable. This isn't a factor for your average private company because they can't trade generally, but if you're doing these liquidity events, you have to take that into consideration, which is a very much a public company procedure. The other things that frankly have already been mentioned, but I'll flag a little bit more. If you've worked on an IPO, you spend a lot of time on cheap stock. If you've worked on an IPO, you've seen the SEC's cheap stock comment, which is show us all issuances of equity in the past year, and tie the price along, and they want to make a determination on whether because usually the way that it works in an IPO, current markets aside, is here's your valuations, and then they spike, and then here's the IPO price, so you have to justify your prior valuations. I think this is the second market provides sort of an interesting opportunity to peg fair value at a price that's determined based on third-party sales, which is the highest level for your cheap stock analysis, third-party transactions. And the same thing for 409A. So 409A is a tax rule, and I won't go too much into it because I'm not a tax lawyer, but essentially it's an excise tax for executives on deferred compensation. And if it's granted at below fair value, then they have to pay, I think it's like 20% of that. So it can be substantial if it's found that your grant is at less than fair value, and that's why it's a concern if you, again, you want to regulate what your actual valuation is, so that if you peg your grants at a particular value under 409A, if that's found to be below fair market value, then you could be in, you could have a tax problem. Your executives could have a tax problem. And I guess that's really the sum total of my program. I tried to keep it relatively brief, but I'm excited for this development. I think that Second Market, is clearly the leader, and companies like Second Market are all forging a path for liquidity for these private company securities, and it'll be interesting to see how it continues to evolve.
Thanks, Eric. You and I had discussed previously the inadequacy of the current 144 little a definition of accredited investor. And when you and I talked, we were really talking about what would you have to move that level up to. Anne Marie's solution seemed to involve another way of handling it, and not looking exclusively to the net asset value or the income of the purchaser, but the size of the purchase. Anne Marie said the minimum purchases are 100K. What do you think of that as an alternative for the 144 little a definition of accredited investor, if you could afford this size investment without a loan?
So you would essentially draw a line. Would this be like an SEC rule or just an institutional practice that you're not going to allow less
Either
than,
way.
I think it would be tough for the SEC to take that position only because they've been fitting into the Ralston Purina case, which is 1952, and basically it defined, private placements as being class based.
I asked him to, if he wouldn't mind going last, in part because I know he's the most patient of all the panelists, and I figured it must be a little bit upsetting, but there are some of these traditional markets still out there, and I gather you work for one of them, TR, and maybe you'd like to say a few words in defense of the traditional market as an alternative to this.
Thanks, David. And no, I'm listening to all this, and I don't even think it's a matter of having to defend the traditional markets as much as it's one of the many pieces of the puzzle that, Anne-Marie talked about, the private securities market, we talked about the 144A market, and we provide a different type of market. So I think all these fit together. I thought it was interesting, your quote from the guy at LiquidNet calling these new securities an asset class. I mean, I think that might be what it is, but there's always, I think, going to be the need for the publicly traded securities as an asset class, even for qualified, even for QIBs and for accredited investors. So, I think that one of the great parts of our capital markets are the innovation and the varying ways that people come up with to raise capital. But I don't think any of these other alternatives will necessarily supplant the need for traditional public offerings. I know we at the company share some of the regulatory concerns for public companies, especially around Sarbanes-Oxley, and we've done some advocacy around that to take some of what we see as unnecessary burdens off of public companies. But I guess I'd have to say also we don't think that they're all necessarily bad things. They might not be the right thing for every issuer, but they a lot of those protections are, a lot of those requirements are there to protect the ordinary investor who puts their money into publicly traded stocks. So when I think about what advantages traditional exchanges continue to bring, there are three big areas: access, liquidity, and disclosure. And fundamental advantage of traditional exchanges is that they're open to everybody. That you get the broadest possible investor base. It's not limited to just accredited investors or to QIBs. So ultimately, an issuer that wants to access capital from the world at large, should go to, or will have to go to, a traditional exchange. And that access, we think, brings probably the best price discovery, the best liquidity to the public markets. From the liquidity standpoint, just to build on that a little more, I mean, that's, by definition, the private securities markets are, I guess it's a little less, listening to Eric, it's a little less the case with QIB markets, but the traditional exchanges probably give the best opportunity to freely trade securities. And, you may, when you have an investment in a private security, there are necessarily going to be restrictions on your ability to resell, which are the right things for some investors, but they're not the right thing for all investors. so that coupled with the fact that you have a broader ability to raise capital through a broader investor base, the liquidity and the access bring two very important benefits to the market. And I think probably what we see as the main benefit is the mandatory disclosure regime for publicly traded securities. So we have uniform requirements. Everybody gets the same information, not just investors, but actually the public at large with public disclosure. By definition, a private securities transaction, some investors may get access to some information, but it may depend on the type of investor, whereas a public investor has the same access to information that all other investors have. And I think that there's risk everywhere. Obviously, every security is risky, but I think the fact that you bring people into the public markets lowers some of the risks that you might have with private securities. And this is, again, not to say that any of these are good or bad, but they just play different roles in our capital markets. So I guess that's to tie it together, try to be brief, is that we think that there's still an important role for the exchange and to work with the other types of markets, but to ultimately serve as a very important focal point in capital raising.
Thanks, Theodore. I'll ask you if you could share any corporate secrets here. NYSE going to set up a secondary market for private companies?
Not that I know of. Not likely. I mean, that it also, from a legal standpoint, it creates issues. Even if we wanted to, it creates issues about whether something like that would be considered a facility of the exchange for regulatory purposes. We've got we don't have a private securities market, but we do have an ATS that trades over-the-counter and pink sheet securities, and we've had some occasional conversations with the SEC about whether that's properly separated from the exchange such that it's not the exchange trading on registered securities.
Well, why don't we open this up to the audience, and you could either ask your questions now, or you could, we do have, thanks to Dewey, some refreshments, or you could ask them later hanging around the refreshment area. Any questions from the audience? There are. Good. Mike?
This is for Anne-Marie. Mike and Anne-Marie.
Don't forget we're friends, Mike, so be calm. Okay.
Just a question. Has anybody approached your platform to do a prepaid variable forward contract on the private securities?
No. We don't do derivative transactions at all around private company stock, and we only transact in the common stock itself. And that's also something that's quite different from us, between us and some of our competitors. If you buy stock through Second Market, you're going to get a stock certificate in your name for that actual common stock. So we're not doing anything other than the pure transactions at this point.
Are you hearing that other people are doing those kinds of derivative contracts?
We're seeing, this SPV creation, so that you're getting an interest in an LLC or an LP, but we're not involved in the formation of funds or SPVs at all. We'll sell to them if they are funded, but we won't sell because we've had broken transactions historically with, as I said earlier, SPVs that were created but not fully funded. We don't transact with those types of funds anymore either.
This is for the panel. Can you speak to the risk associated with a fully funded SPV being looked through so that all the underlying investors count towards the 5 investor rule? I've heard some people say that, like hedge funds, there's no look through. I've heard that companies have taken a conservative view and they're saying we don't want single purpose SPVs, it has to be a 50% threshold. And I've heard some people say no, it's a pure look through no matter what. So what is the I know it's a gray area, but what is the theory?
Andrew?
That's a really good question, because I think that is a question that's on a lot of people's mind. And I don't know that there really is a lot out there. I know that when Chairman Shapiro responded to Darrell Issa one of his requests for informations, there was a very, very small piece of guidance that she put into her response. I think it was in one of the footnotes. The case that the commission cited was frankly not very helpful. There are some old enforcement actions with Bacardi that get into, 12G5, 1B3, I think it is.
Specific.
Yeah. Look, I think that that's an issue that is under consideration by the staff, and they're looking, I think, at a bunch of issues kind of holistically. And I think they may speak to that hopefully sooner than later because that question is out there.
And this is the question is really whether it's a scheme to avoid 12G.
Yeah.
So it's without any real guidance, basically. You have to essentially just structure it so that it doesn't look like a scheme.
Yeah. I mean, I know that I was at a conference. I guess it was last January where there was a member of the corporation finance staff that spoke, and they were talking about the Goldman investment and SPVs and that portion of 12G51. Sorry, I was saying I was at a conference in last January, a securities law conference, and there was a member of the senior staff that was there, and he was talking about the Goldman investment and 12G51, and I think it was the nonverbal communication that was more interesting than the verbal communication. So I think that there's a healthy degree of skepticism on the part of some members of the staff, and you need to keep that in mind when you're structuring these things.
And I can tell you that last fall, San Francisco SEC Enforcement sent out information requests to about 20 market participants, including our company, asking questions around SPVs, and the context of the information inquiry was pre-IPO pooled investment funds. So we've also heard that they're looking at whether or not these single stock SPVs need to be looked through, and I think they need to put rules out. I mean, I think if they take a view, they'll do some sort of rulemaking around that, and I think that's going to be helpful to the whole market. But I'm not sure what their thinking is as of right now.
Sure.
Hi. I'll make a few comments, but which always are bad for me because it doesn't make me a favorite guy around here. But I've been old enough to be on the precipice of many of these new innovations, so I always have a bit of a skeptic. The premise seems to be in all these things where it's an ability for these companies to get capital, but in fact it doesn't. No capital goes to the company.
Correct. It's all secondary on our market right now.
So it's really not solving the capital problem for small companies. So I'm just trying to figure out why it's so important to have a market for shareholders. Is it because you can't attract them? I mean, how big is that market for most companies? Other than Facebook, you get 701 limitation on how many shares you can have in an option plan to begin with. How many companies really can access this, to get liquidity for shareholders? And really, is that enough of an argument to do this?
Well, I can tell you we have information on we have a two-tiered platform. The first tier is available to anybody who's interested in illiquid assets or alternative assets. And we have publicly derived information on 17,000 private companies that have had at least one round of preferred funding. I don't know what the ultimate numbers of companies that could take advantage of something like this. We are licensed to do primaries. We've done primaries in the past, but I think the way that we've been looking at the market is there are a lot of ways, at least in my mind, for smaller companies to do primary capital raising. There's a lot of market participants who provide that ability to companies. Where there's not a centralized or I think particularly efficient way is for investors who have come in through primaries or through employee comp plans to find liquidity for their shares. And that's sort of what we've decided is a niche that we wanted to be focusing on at this point in time. And we're approached every day by companies who want us to help them do primary capital raising. One of the bills that's out there also in the House right now that I don't think we talked about is a crowdfunding bill that you may or may have read. We were talking about it earlier before the program started, which I think is really a remarkably interesting piece of legislation in a lot of ways. It would allow private companies to raise up to $5 million. It would allow retail investors to invest in those companies up to the lesser of 10,000 or 10% of their net income. What scares me about the way the legislation is written right now, or not scares the wrong word, but it doesn't mandate information providing. It doesn't mandate that the transactions occur through a registered broker-dealer. It doesn't, and it specifically excludes investors who take in these crowdfunding transactions from counting towards your 500 shareholder threshold. So it's a really interesting bill. And if that sort of legislation passed, I think you're going to see a sea change in the market for very small companies having a lot more access to capital. But there are a lot of participants in the market. There's a company called ProFounder that was doing these transactions. There's AngelList. A lot of companies are helping small companies find ways to raise capital, friends and family programs, or outside of friends and family programs. So there's a lot going on in the primary market, and I think we'll see a lot of developments there over the next couple of years.
I think just by definition, it has to go that way. This market's not going to be big enough just selling employee shares. In my view, it just can't be big enough over time for enough people. I don't know how much revenue you guys generate from it, but do you think there's going to be enough, to really create a market that's going to be big enough, outside of Facebook and Twitter?
I don't know the answer to that question. I mean, we're lucky in the sense that we trade multiple asset classes, right. So private company is just one of our asset classes, and that diversification really helps us figure out what makes sense for us to be in. I think that there are a lot of companies who don't want to be public because they've gone over 500 shareholders. I don't know that that's going to change. And more companies are being started every day. So I don't think there's an end to the pipeline of companies that could take advantage of a program like this.
But we're talking about a program that's designed for sophisticated investors, not for the retail. And now we're talking going retail. So you're really going right from, we're just going to trade in shares, employee shares, to primary offerings, to unaccredited investors.
That's not a place we want to be.
But that's where it's going to have to go to make enough money for this market. And there's so many people that want to do this. It can't be just, employee shares.
There needs to be more to allow a lot of market participants to make money in this, but
Well, there's only 6 million, households that can even be accredited investors in the U.S. Okay, so we can go through the numbers. The numbers just don't add up to a market that is not underserved today because, first of all, VCs can already sell their shares in the secondary market. They already have the ability to do block trades. Gold's been doing these trades for as long as I've been around. So everything that we're saying we're doing here is already being done. There's nothing new. At all, including the law. But the premise that I'm hearing, and I'm hearing people go to Congress, is we want to do this because we need the liquidity for these small companies, but that's not what we're doing. And I'm just wondering how this is all playing out here.
Well, wouldn't you be able to raise VC capital easier if the VC funds knew that they would have an opportunity to achieve liquidity before an IPO? At least have that opportunity.
I don't know. Maybe it's not a good thing. They can still sell their shares now. They don't have to be for IPO.
But at some discount. And
that's
right. There's a discount too, but
discount to
hopefully it's a lesser discount.
There's no discount because there's no market price to discount off of.
Okay, but that's not a good response, Emery. The fact that you're just saying we don't really know what the price is.
That's not what I said at all.
But
I'm just saying
there's no discount.
you're saying there's a discount. I'm saying the price is set by a market that's private.
Okay.
And it's tied to the preferred stock
price. Well,
price.
But if you actually were able to get the transactions, right, that are happening besides what is on your platform, you might say there is a discount. But I actually know for a fact there is a discount because I know what other people trade this stuff at. Anybody in the market I'm a lawyer, so what do I know, right? The bankers group do a much better job of price discovery than I can. So if I can get that information, I'm sure they can.
Well, the other thing, the way that I think markets like ours help price discovery is if you have one institutional investor who's going in, and I know T. Rowe Price bought a lot of secondary shares from Facebook employees in an internal market. What motivated T. Rowe Price to pay the best price possible with no competition on that pricing? So at least through our market, and again, one point I didn't make is that 80% of our buyers are institutional investors. We're not talking about doctors and dentists, or lawyers, God bless us. That's not who we're generally selling to. So we're talking about hedge funds. We're talking about institutional buyers. who are forced into a more competitive bidding price, more competitive bidding situation than kind of might have historically occurred. And I think that's actually really good for sellers.
Yeah, no, again, after you exhaust the 20,000 of those,
We'll find something else.
yeah.
Every day the guys are coming to me saying, what's the next? No, I don't mean retail. I just mean we'll find another asset class. Right.
Everybody else will be, chasing this market. We'll be into retail before long. Mom and pops will be buying.
Well, that's why we have a minimum, and I thought that was a really important distinction for us to make. That and 100,000 is our absolute minimum, but we generally, as I said, the average transaction price is about $1 million. So we're not looking to sell to retail accredited investors in small dollar amounts in VC-backed private companies.
I'm getting 20 calls a month saying, "How do we do that for 100,000?" They want to do what you're doing, but they want to have a much bigger base. And then when you run out of Twitter and Facebook.
Give them my number. They can call us through us. Happy to take
But when
business.
when we get done with Twitter and Facebook and the like, then what's the next wave of private company stocks that's going to fill the pipeline? Right?
We have about 250 target companies, and maybe we're transacting in 10 to 15 companies at any particular time. So it's not a huge market, but it, and I'm not pretending that it is a huge market.
I know you're not. I'm just wondering where this is going because I can't figure it out. And I'm also wondering what's the real business case for it.
Well, it can't go truly retail, like you were saying. It can't evolve to that. I mean, you have the 33 Act.
I
Right.
understand.
I think that's kind of where you take the conversation from where the gentleman's saying is, you're talking about us being at a precipice, but we're in a circular state to some degree where you're somewhat constrained by where we are within the regulatory environment now. So do you envision it, another step, that's quasi-public so that you're allowed greater freedom to distribute and bring in new shareholders, but there's going to be some gatekeeping that is short of, a full public company? That would seem like a more likely result from the discussions and the bills and the things that are rotating out there that would actually potentially be progressive versus opening the door for crowdfunding where there's, retail, distribution or what have you. So I'm just curious, do you see that as the likely result or,
The bill that has been put up in the House, remind me again, Andrew, who's the representative who put that up?
The one on the 34 Act number, or
Yeah.
the one on the general solicitation?
34 Act.
Schweikert?
Wait, which the 500 shareholder bill? Is
Yeah.
Schweikert general solicitation? Schweikert.
Yeah.
Yeah.
In any event, it bumps it up to 1,000, but excludes from that number any institutional investor.
Not anymore. There's been an amendment to it, so now they're only excluding employees who took under an exempt equity comp plan.
Yeah.
It was drafted so that it exempted out accredited investors and employees.
It was accredited.
I mean, I
Yeah.
think the more interesting things, I don't know what will become of them, but the more interesting thing, at least for me, as someone who likes the 33 Act more than the 34 Act, is to wait for the release the concept release that's going to come out of the commission. What are they going to say about general solicitation? What's going to happen to the bill that's in the House that would do away with the ban on general solicitation for 506?
It's all of 4.2 now. That one's been amended also.
Okay.
There were a whole round of amendments last week, and I don't mean to interrupt you, but that's one I think is really interesting is that they started with eliminating the prohibition in the context of 506 offerings, which we saw, to eliminating it whole from 4.2.
Yeah.
So you could generally solicit for 504, 505, 506, and that's going to feed into 4.1.5. So you'd be able to generally solicit for 1.5 transactions as well.
Well, there would be your new
Right.
market.
For my immigration and everything else.
Right.
It'll be fun. I'm looking forward to it.
Quick question. Given that, at least for now, the preponderance of securities being sold are called social media space, putting aside for a second whether you believe we're in a bubble or not in a bubble, if there is a correction, and the correction happens before the industry can diversify out of the tech social media space, kind of for Maria, but also, is there a risk of a raft of lawsuits killing this industry before it can evolve? How susceptible, I guess, are market participants going to be to lawsuits if there is some massive social media correction and that is the preponderance of securities being sold? Traditionally, my understanding is that broker-dealers, if they follow the rules, they may get sued. Everyone can sue everybody, but they're fairly immune to those lawsuits, as long as, especially if they're accredited investors, the big boy rule. But is that a concern for this sector in the next, let's say, 18 months to 2 years? Is there anything, that's a way to phrase it, is there anything about this sector that is more susceptible to lawsuits, aggrieved investor lawsuits, than just say some guy selling equities?
Yeah, the other requirement for broker liability would be that there'd have to be a recommendation, and my understanding is that there is no recommendation coming out on these. It's just an availability and accessibility.
Even for those firms, I know second market does not do this, even for the other firms that maybe have a research component? There are, some firms are embedding third-party research or their own research. So would a firm that embeds research be more at risk than one who doesn't?
I would suspect it depends how that research is being embedded. There a raft of rules that's in public offerings as 137, 138, 139, 168, 169 as to what is acceptable research in the face of an offering without. Now that's a different question. It's not going as to broker liability, but that's going as to liability as to whether or not you become an underwriter. But I would think that it would be a similar kind of question as to whether or not you're making a recommendation.
Yeah, I think as far as I know, doing a recommendation in a research report usually isn't considered a recommendation like that triggers suitability obligations like you would get if you call your broker and say, what do you recommend? And they say, buy Facebook. As opposed, I don't think there's a whole separate round of rules around research reports about how they have to be vetted, but I don't think that usually triggers suitability obligations.
Why don't we thank the panel very much. I should make a disclosure, which I did not do up front for a variety of reasons. When the school asked me to pull together this program, the idea was to get experts who were not graduates of the school. I knew from the start, get-go, that Anne-Marie was and TR was. It was stunning. I looked around and I kept on asking people who's the best. This is the panel we ended up with. And everyone to my right is a CUA law graduate, and I'm real proud of that and proud of them. Thank you very much.
And your students.
Yeah.